You could once go to federal prison for 10 years simply for refusing to hand over your gold coins to the government. Not for stealing, not for smuggling, for keeping property you already owned. In 1933, the United States required every private citizen to surrender their gold to the Federal Reserve by May 1st. The penalty was a decade behind bars and a fine that would equal roughly $240,000 at today's value. The government paid you for the gold, $20.67 per ounce, but the price was set by the buyer. And 1 year later, that same gold would be worth dramatically more on the Treasury's books. And the one man who dared to fight this in court and became the government's example, he never got his gold back. The country was drowning. In the 3 years after the stock market crashed in October 1929, more than 9,000 American banks failed. Families walked into their local branches and found the doors locked. Life savings evaporated. By March 1933, the banking system itself was paralyzed. State governors were declaring bank holidays to stop panic withdrawals. On March 5th, Franklin D. Roosevelt declared a national banking holiday, shutting every bank in America. 4 days later, Congress passed the Emergency Banking Act, giving the president extraordinary powers to regulate currency during a declared emergency. But the weapon Roosevelt would use to seize gold came from an older, stranger source: the Trading with the Enemy Act of 1917, a law written for wartime that Congress now repurposed for a banking crisis. On April 5th, 1933, Roosevelt issued Executive Order 6102. An executive order is a directive from the president that carries the force of law, requiring every person in the United States to deliver all gold coins, gold bullion, and gold certificates to the Federal Reserve. The order covered any gold holding above a small personal threshold. The government paid the official price of $20.67 per ounce in paper currency. Technically, it was a compulsory sale, not a seizure without compensation. But the owners had no choice in the sale, and the price was fixed by the federal government itself. Roosevelt called it an emergency measure. The Treasury called it a bargain. Most Americans complied. Between April and June 1933, the Federal Reserve collected more than $1 billion worth of gold. The Attorney General publicly warned that anyone refusing to surrender their gold faced 10 years in prison and a $10,000 fine. The press amplified the threat. Time magazine reported in October 1933 that holdouts were being reminded of those exact penalties. Yet, despite the aggressive rhetoric, the government almost never enforced them. The one man they chose to make an example of was not some back alley smuggler. He was a Manhattan attorney. Frederick Barber Campbell kept 27 gold bars, approximately 160 kilograms, roughly the weight of a professional welterweight boxer, in a safe deposit box at Chase National Bank. He was a Harvard Law graduate, a director of insurance companies, and a member of Manhattan's most exclusive clubs. He was not the kind of man the government usually targeted, which is exactly why they targeted him. The government wanted a defendant who looked respectable in a federal court. When Campbell demanded his property in September 1933, the bank refused, citing Executive Order 6102. Campbell sued the bank. The federal government responded by indicting him the very next day for failing to register as gold. His defense was straightforward. The president had exceeded his constitutional authority. The government made it clear that if Campbell continued to fight, he would face disbarment and professional ruin. Before the case could reach a definitive constitutional ruling, a federal judge dismissed it on a technicality. The order had been signed by the president, not the Secretary of the Treasury, as the law required. Campbell himself was never convicted, but the government kept his gold anyway. And the court's opinion made clear that had the paperwork been correct, Campbell would have lost. Campbell's case was a constitutional challenge. But the government was also running a criminal operation. Secret Service agents simultaneously arrested more than a dozen men across 4 cities in a coordinated sting, seizing $24,000 in gold. The message was the same for everyone still holding gold. You might beat the charge on a technicality, but you would not keep your metal. But the real legal blow came the following year. On January 30th, 1934, President Roosevelt signed the Gold Reserve Act. This statute transferred title of all monetary gold, every ounce held by the Federal Reserve, private banks, and individual citizens, to the United States Treasury. The federal government now owned virtually every significant gold stock in the nation. Then it did something that still shocks economic historians. It revalued gold from $20.67 per ounce to $35 per ounce. The Treasury had just paid citizens the old price. Now, the same gold was worth nearly 70% more on the government's books. The profit, the seigniorage, or the difference between the old price and the new, went directly to the federal government alone. That single move generated roughly $3.4 billion in paper profit for the Treasury in 1 month, approximately 1 full year of ordinary federal tax revenue at the time. American exports became cheaper on world markets, but the real cost was borne by every citizen who had surrendered their gold at the old price. The order also banned the minting of gold coins for circulation and required licenses for any gold transaction exceeding 15 ounces. For the next 4 decades, private gold ownership in America existed only in memory and in underground black markets. Then, quietly, the law reversed. By the early 1970s, the United States had abandoned the gold standard for international settlements. The restrictions no longer served any monetary purpose. On August 14, 1974, President Gerald Ford signed Public Law 93-373, which effectively reversed the 1933 and 1934 statutes. After 41 years, private citizens could legally own gold again. There was no ceremony, no national address. The bill was buried inside an international development package. On January 1st, 1975, Ford issued Executive Order 11,825, canceling every previous executive order that had regulated gold transactions. The confiscation era was formally over. In 1977, Congress passed the International Emergency Economic Powers Act, or IEEPA, a law that replaced the old Trading with the Enemy Act for most peacetime emergencies. IEEPA gives the president broad authority to freeze foreign assets and impose economic sanctions, but it sharply limits the power to seize private property without compensation. Legal scholars generally agree that IEEPA does not grant the federal government a general confiscation power over domestically held gold or other assets belonging to American citizens. Today, owning physical gold in the United States is completely legal. There is no federal registry tracking how much gold private citizens hold. Surveys suggest only about 10 to 12% of American households own physical gold in the form of coins or bullion. If you buy gold with cash, the transaction itself requires no government permit. But financial transparency rules still create a paper trail. Under federal law, any business that receives more than $10,000 in cash from a single customer within a single year must file Form 8300 with the Internal Revenue Service. The form records your name, address, and the nature of the purchase. Since 2011, the Financial Crimes Enforcement Network, or FinCEN, the Treasury Bureau that enforces anti-money laundering rules, has required precious metals dealers who conduct more than $50,000 in annual sales to maintain formal anti-money laundering programs. If you inherit gold from a relative, you owe no federal inheritance tax on the metal itself, though capital gains tax may apply when you sell it. These rules do not restrict ownership. They simply mean that large cash purchases of gold are visible to federal regulators. Most people believe the government seized gold without paying for it. It did pay. at a price it alone controlled. Many think thousands of Americans were prosecuted. In reality, only a handful were ever arrested, and the one case that reached a courtroom was thrown out on a technicality. But here is what actually matters. The legal machinery that made this possible was never destroyed. It was just relabeled. The 1933 episode proved that in a declared emergency, the federal government can redefine what you are allowed to own and what it must pay you if it decides to take it.
The courts will likely defer to Congress on monetary policy. The only real protection is political, not purely legal. So if you have a 1-ounce American Eagle in a safe, or a few gold coins inherited from a relative, you are breaking no law.
You do not need to report the possession to any agency. You do not need a license to hold it. The government cannot compel you to sell it at a fixed price. That specific power died in 1975. What remains are the ordinary rules of financial transparency that apply to every valuable asset bought with large amounts of cash. Tomorrow, the property law doctrine that can hand your neighbor a legal claim to your land, not because they bought it, not because you gave it to them, but because a fence sat in the wrong spot for long enough and nobody said a word.